The broadcast is now starting. All attendees are in listen-only mode.
Hi, good afternoon, everyone. Thank you so much for joining us on this very important topic. My name is Maria Mendez. I'm the Training and Technical Assistance Manager here at CICASA. I want to start with just a few housekeeping things. Everyone is on mute, as you all probably have noticed. If you all can remain on mute during the duration of the webinar, you can ask any questions or type in any comments to the questions chat box. I will be monitoring that as we go through and relay that information to our presenters. The thing with the questions and the chat is there will be a break between a couple of the topics that Kerry and Kelsey will mention when they introduce themselves. That'll be the time when we will open it up to questions. So as questions come up, please feel free to type them into the questions chat box, but know that we will have a designated time to get those questions answered. The PowerPoint and any handouts that are available will be sent up in a follow-up email immediately after the webinar. And it will include a link to a SurveyMonkey. So we've started doing something a little bit differently. If you've attended our webinars before, you would get an immediate survey as soon as the webinar ended. But we're hoping, since we want people to be able to have a little bit more feedback with us, we're doing the SurveyMonkey so that there can be some of those open-ended questions. So we would really appreciate it if you would all head over to SurveyMonkey as soon as you get that email from me. The feedback is greatly appreciated, and it really helps us to engage with you all and provide content that you all are needing. With that being said, we do have a quick poll for you all. We want to know who's on the call. So I'm going to go ahead and launch this poll. If you all could go ahead and vote, let us know if you're a student, you're a Title IX staff member, you're a community or a campus-based advocate, or if you're someone else. If you could let us know in the questions chat box who you are, that would be really helpful to kind of give an idea for us at CICASA, but also for our presenters to know kind of what the audience is to help in anticipating any questions or things like that. So we have about 65% of you who have voted. We'll give you all a few more seconds to get that in. Right now we have about 12% students, 43% community-based advocates, 14% campus-based advocates, and 28% other. So we have a few people who are retired campus-based advocates, some advocates, welcome, Title IX staff and campus advocates sitting all together. So thank you for joining us on this call. I'm going to go ahead and close this poll and then share it with you all so you all can see who's on the call. We also have a school-based therapist, campus-based advocates. So we have a pretty diverse group with us today. So we have about 10% students, 8% Title IX coordinators or Title IX staff, 43% community-based advocates, 13% campus-based advocates, and 28% others. So thank you all for being here with us. We're so excited to be able to provide this and to partner with Kerry Simon, who is a Title IX attorney, and Kelsey Brown, who's our very own policy intern here at CICASA. So at this point, what I'm going to do is I'm going to go ahead and turn it over to our presenters. Thank you all for being here and for providing this very valuable information.
Thanks so much, Maria, for setting this up. I am Kerry Simon. I'm one of the two presenters. I'll quickly introduce myself and allow Kelsey to do the same. We're here to talk about the proposed Title IX rule recently issued from the U.S. Department of Education Office for Civil Rights and how each of you can make an effective comment to that during this period of time called notice and comment that we're in right now. We have nearly 60 people on the call, so that means we're going to get 60 effective comments out of this wonderful webinar today, and then hopefully each of you can find five other people in your life to do the same. So we're going to have a lot of effective comments through this. As Maria mentioned, I am a Title IX attorney at the Fairburg National Law Group. I formerly directed the Congressional Victims' Rights Congress and Caucus at the U.S. Congress, and was the inaugural fellow at the Harvard Law School Gender Violence Program, where I was doing Title IX work. So now what it means to be a Title IX attorney for me is I have a full-time practice of representing survivors of school-based sexual violence in the K through 12 setting and in the college setting. And in that, I mean, I do direct services. I assist survivors in getting accommodations so they can safely and fully access the benefits of their education, in going through campus disciplinary proceedings so they can hold the perpetrator of sexual harassment or assault accountable through their university proceedings. And then I also do civil litigation when folks feel their civil rights have been violated, or file complaints with the Department of Education or the Department of Justice in the aftermath of someone experiencing civil rights violations. So I really look at sexual violence from in the education setting from a civil rights perspective, from a Title IX perspective. So, you know, these rules have a day-to-day impact on the survivors, these proposed rules, these dramatic changes that are happening to Title IX under Betsy DeVos's Department of Education. And I am really excited about the opportunity that we all have in Colorado to use our expertise and voices to effectively comment on these rules. Turn it to you, Kelsey.
All right, thanks, Kerry. So my name is Kelsey Brown. I am the policy intern with CCASA. I'm also a graduate student at Metropolitan State University of Denver, finishing up my master's in social work. I'm really interested in doing some macro practice social work, so this is really what I have found fills my bucket. So over the last, I don't know, 3 weeks or so, I've been doing a lot of trainings around what these potential changes are and how people can engage in notice and comment, and I've talked to over 100 people so far. So Kerry and I are really excited to bring this to you all as more of an in-depth how to write an effective comment to help you answer questions and feel more comfortable engaging in this process.
So I'm going to tell you about our thoughts on how this presentation is going to, what we're going to cover today, what sort of our strategy is. So we're going to cover the who, what, where, when, why, and how of notice and comment on what exactly is this comment, who can submit one, how do you submit one, and how do you make it effective. I think we're going to split that. Really, you should think of it as two buckets. One is sort of the logistics around how to do this and what's going to be most useful and why we're really doing this. And the second half will be the what category, and that's going to be the substance. What is in this rule and what are issues that you might want to raise a comment on? And we'll sort of present a menu of things that have changed in this rule that you might think, okay, this fits into my interest or my expertise or my experience or what I've seen, and it's these couple of issues or single issue that I want to respond to. So we'll have a sort of in-depth of how to think about doing this and sort of what goes into it, and then a second piece, which is more about the substance. One thing I have been thinking about and hearing is that, you know, there's a strong emphasis on having substantive comments so that they can be more effective. And we're definitely going to explain what that means today. But I think at the same time, that emphasis has made people feel a little intimidated. So we want to dispel that and say this is totally doable. We're just going to lay out an outline of what this should look like and what will be effective so you can have the most impact. And when we say sort of impact, there's also a whole bunch of folks that have submitted form letters, and that's really great too. We want that too, to kind of show the number of people that are engaged and care about Title IX. But when you have a substantive comment, there's a requirement that the Department of Education read that comment and respond to it specifically. So we want to be raising the types of comments that require them to respond, and we'll kind of get more into that in the why category, why this is so important. So let's launch into it. We're going to start with some background. So here is what Title IX is. So Title IX is an amendment to the Higher Education Act. It came out in 1972, over 45 years ago. This is Patsy Mink. She was the original author of of Title IX. And here's the 37 words that change the world. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal assistance. So I think that societally, and probably lots of you on this call or historically have thought of Title IX as a sports law. And you'll see in these 37 words that none of them mention sports. And that's because sports as a form of discrimination in the school system against women and girls is an interpretation of these 37 words. So these 37 words just simply say that there can be no discrimination based on sex in education if you receive any federal money. And the sports piece is an interpretation, and so are all the other pieces. So I want to sort of root in, why is Title IX addressing sexual assault in our K through 12 schools and in our colleges? And when these 37 words were written, what Patsy Mink and others were thinking about was the basic discrimination we were seeing in our schools, that, you know, Columbia was saying 5% of our class goes to women. Well, that means 95% of our class goes to men, and that's just clear on its face, exclusion of women from educational access and discrimination. You know, an old case at Georgetown in the early days of Title IX said that married women couldn't get degrees. And that was the idea that they didn't need them because they were getting married and could rely on their husbands. So that is a form of discrimination because it prevents someone from accessing their education. In the same way, sexual harassment, sexual assault by peers or by other members of the academic community can prevent someone's access to education because they would otherwise drop out and not go to classes, and all the things we see happening. So that's the basic reason why sexual harassment in schools is considered a form of sex discrimination in education. That's why we're here today. And then the next question is, how is this enforced? So if we can't have sexual harassment in our schools, and schools have to respond to sexual harassment, who is responsible for enforcing Title IX? And there's really two ways that it's enforced. One is through the U.S. Department of Education and one of their specific offices, the Office for Civil Rights. And the other is the courts, so the U.S. Supreme Court and others. So in 1992, in a case called Franklin v. Gwinnett, the U.S. Supreme Court held that sexual harassment in school was a Title IX issue, that was something. The sort of the same way I laid it out was they said, yes, we get it. Sexual harassment in schools is a school issue. So that was in 92. Then in 99, these two cases that I mentioned in this slide, Gepser and Davis, the Supreme Court laid out the standards that a victim has to meet when they're suing their school to say their school violated Title IX for their failed response to a report of sexual harassment or sexual assault. And I should say, really, you should think of it as sexual harassment as a broader category: sexual assault, stalking, dating violence, domestic violence, verbal harassment, online harassment. All of those fall under that language of sexual harassment. So that's where the courts laid out the standard, but they'd been saying it since the early 90s that really courts have been looking at it. Separately, but that's, requires the victim find a lawyer to sue the school on their behalf. Second, lots of people don't want to do that, but they do want their institution to be investigated and for them to be complying with Title IX and not be discriminating based on sex. And that's where the U.S. Department of Education comes in. They too have the mandate, if they're giving you federal funds as an educational entity, that you have to comply with civil rights laws, including Title IX. So the way we understand and interpret what Title IX means are through these two entities. The courts look at individual cases and determine whether or not a school is liable under Title IX, and the Department of Education sets guidance to tell schools, this is what you need to do to comply with Title IX. And after they set that guidance, individuals at schools can go to the Department of Education and say, this school is not falling in line with your guidance, hold them accountable, force them to change their conduct. And the Department of Education responds, conducts investigations, and forces schools to change their behavior and their processes to comply with Title IX or otherwise lose their federal funding, which they never do. Schools always change their behavior, change their processes in response to those type of investigations. So that's why it's so important that what the U.S. Department of Education says, schools do, because otherwise they're going to have federal investigators require they do it. So today, we're not talking about what's going on in the courts. That still lives, that's still happening every day. We're focusing on what the U.S. Department of Education is saying about how schools have to respond to sexual harassment.
So as Kerry mentioned, the Department of Education releases guidance documents that help schools understand how the Office of Civil Rights interprets Title IX and what that means for the way that schools need to act in order to stay in compliance with the law. And so here's kind of a brief history, an outline history of what these guidance documents have looked like over the years. So there's one released in 2001, and that was a sexual harassment guidance, essentially telling schools that they had to act on sexual harassment. And then there was the April 4th, 2011 Dear Colleague letter that laid out further guidance on ways that schools need to act when students say, this is happening, and so ways for them to respond that will help them comply with the law. And then there's a 2014 question and answer document that's pretty lengthy and really sets clear guidelines of if this happens, this is a way that you should respond. So all of those were used, again, by the Office of Civil Rights to let schools know what they needed to do to be in compliance with the law, and they're guided by the Department of Education. So in September 2017, the Department of Education rescinded the 2011 and 2014 guidance documents, and effectively just took everything back to the 2001 sexual harassment guidance, which was far more broad than the Dear Colleague letter and the question and answer document. So since then, schools have been living in sort of an in-between interim world until November of this year, November 29th, the notice of proposed rulemaking was published. So now you will notice that this is not a guidance document. It is a notice of proposed rulemaking. And so what that means is that is a proposed change to the law. And so instead of it being like an internal document that the Office of Civil Rights creates and says this is how we interpret the law, it's going to be an actual change to the law itself, which means that the public gets to comment on this. And so in this case, there's a 60-day notice and comment period. And so that will end on January 28th, 2019. And in that time, the public is open to submit their comments on these proposed rules. The comments are public, and so you can look at what other people have said. And once those are all collected, when the notice and comment period ends, then the department will go through all of those comments that they've received to issue their final rulemaking. In that final document, as Kerry said, they have to respond to all of the substantive comments. And so they will say whether or why they did or did not adopt the changes that are proposed through the notice and comment period.
So let's just take a quick overview of what the proposed rules do. And I mentioned at the beginning that we're going to get into the substance at the end of this, the second half of this presentation. So I'm just going to briefly talk about the three big buckets of what this school did, and then we'll get into those in very specific detail to give you more of a menu of what you can respond to. But before we sort of get more into the why, who, whens of how to do this, we just wanted to quickly say these are the three things the rule really does. So one, it really puts a big limit on the sexual harassment that a school has to respond to at all. So it says a lot of it can be dismissed or ignored. I know that sounds shocking, but that's actually what it does. The second thing it does is tips the favor of those accused of sexual harassment and against the victims of sexual harassment. So in several ways, it makes the process more in favor of those that have been accused rather than an equity standard, which is historically what's been the case for Title IX, which is an equality law. And the third big bucket is that it weakens the support for survivors, the sort of accommodations and remedies component to address the impact of sexual harassment on their education. And so that's another area that I think is really significant. So we'll get into those buckets more specifically. I just wanted to give you an overview about why a lot of people in the community want to comment this and are concerned are sort of these big buckets. I think that we all are concerned. That's why we're all on this call. But let me talk to you about why submitting notice and comment is important. And I had a mom of a survivor say to me the other day, I'm willing to do this, but I don't think that the Department of Education is going to care about what I say. Like, I'm not going to make a difference to this rule. So I said, well, let me explain to you why, it is worth your while and why I think you should do it. So here's 4 reasons. The first is it's possible that our suggested changes will improve the rule. Indeed, there was a leaked rule, and conversations by folks like CICASA and myself and others helped do some improvements before the actual rule came out. So we've already seen some improvements. One way to think about it that someone said to me, that was mentioned to me by someone who worked in the government for a while is, the Department of Education is a large institution, and while there are true believers in this rule, there's plenty of people on the inside who really want to see the right thing done for sexual harassment victims, and they might just be waiting for your perfect comment to have as a hook that they need to improve the rule, to make an argument to say, look, this comment was raised, they're raising different data or different personal experiences that we weren't thinking about or that we hadn't considered when we wrote this, let's revise. So it's possible that your comment could improve the rule, and that's a huge, huge deal. Second, we're creating a record. So even if they ignore your rules, there's going to be ways that this rule, when it comes to its eventuality, will likely be challenged. And I think there's 2 major ways it will be challenged. One is there's potentially going to be lawsuits to say this should not go into effect, to go to the courts and say, look, they ignored the record. They ignored so today, right now, there's been 50,000 comments submitted, and the vast majority are folks that say this is not a good rule. So let's say we get to 200,000. This is going to create a record when someone goes to the court and say this was an arbitrary and capricious act. This was a rule that ignored the will of what commenters were saying and ignored substantive comments. So we're creating a record for that purpose, and also creating a record for the purposes of another administration that might want to change the rules. So I think it's important that we create the record now to show what our views are on these specific things in order to have it for those purposes. So we can improve the rule, we're creating a record. 3, for those who don't want to see this go into effect, submitting lengthy and thoughtful notice and comment that have to be responded to will slow down the implementation of the law. They have to read everything that you submit. So let's say you attach to your comment, you write a comment and you say, this is a really important article that expresses my point, and you attach that as well. You can do up to 10 attachments. They have to read all of that. Somebody has to read all of that. So the time of reading all of that will slow down implementation. And the time it takes to respond to substantive comments thoughtfully will also slow down implementation. So the extent that we can protect people from things that are problematic in the world, slowing down the implementation is meaningful. And then the 4th issue is demonstrating concerns to the administration and to the media that folks have with this rule. And that goes to the sort of dual things that we're looking for. One is substantive comments, which are the most impactful, but the other is a lot of comments, which shows this demonstration of concern to the media and administration. So, some of those things maybe you'll meet and some of them you won't, but ultimately, those are reasons why I think it's worth your while to submit a comment.
So the next piece is who can submit a comment. And the answer is anyone. And we really hope that anyone and everyone who hears about these proposed rules will submit a comment. So you, on this call, you can submit a comment either in your professional or your personal capacity. And we'll talk more about effective comments, but personal experience. So if you have worked with a survivor of school-based sexual harassment, or if you are a survivor, your personal story can make a big impact on your comment, on the effectiveness of it. And so we really want you to share that. We also feel like anyone who comes into contact with schools or works with Title IX in any capacity would be people that would want to comment on this, and that we want to comment on this, because again, your experience in this is valuable for guiding what the future could look like. And we also need people who have experience in this, or who hope to have experience in this. Sorry, I should rephrase that. Not hope to have experience in this, who want to work with students, who want to be social workers, who want to work in schools or be educators, that you are helping to guide the rule that you want to work under. And so really, like Kerry said, you all should submit a comment, and then we should all commit to getting at least 5 other people to comment with us so that we can really try to reach as many people as possible.
Hey, Kelsey, before you go on, I wanted to mention on the last slide of the who is that it asks, when you submit a comment, it asks for your name, But if you wanted to submit anonymously, you could either write anonymous, you could write Jane Doe. If you, for especially for survivors who want to take that position, so understandable. So you can still submit under those names. If you want, I can submit on your behalf, or the Harvard Law School Gender Violence Program has offered me for my clients to have them submit on their behalf. So there's ways that you can either have another submit on your behalf or just submit as a Jane Doe. So just wanted to raise that as you're thinking about, well, how do I submit as a parent or as a survivor, to the extent that that's a significant issue, which I know it is for many.
Thank you, Kerry. So again, like I mentioned, this is a 60-day period, and so all of the comments are due January 28th, 2019 at 11:59 p.m. Eastern time. So that's the hard deadline there. So if there are several ways for you to submit a comment, so if you decide to handwrite a comment and mail it, it must be turned in by this date. So that's really important. So remember this date. And then where? So there are a couple places that you can actually submit comments. So I'm going to show you really quickly the regulations.gov website so that you can find this rule. So this is, when you type in www.regulations.gov, this is what comes up. And we're going to search school harassment. And there's a lot. So we'll scroll down, and here is the rule. So it's titled, or proposed rule. So it's titled Non-Discrimination on the Basis of Sex in Education Programs or Activities Receiving Federal Financial Assistance. So when you click on this, you will be given a summary of what this is, the date, so we must receive your comments on or before January 28th, how to actually send in your comments, and then the summary and the actual proposed rules. In this open docket folder link here, there is, when we scroll down, so you can see there are 5,369 comments that you can actually read. And so when you click on these or click view comment, it'll pull up the full comment for you to look at. So that can be really helpful if you're wanting to see, arguments for the proposed rules that support the proposed rules, arguments against them, or just see who has submitted so far. And over here, you can see we're over 50,000 comments already received. So when you click comment now, here is what you will see. So you'll see this little comment field, which is required. So you'll have to type something in there at the very least. And then here's where you can upload those files. So like Kerry was saying, you can upload up to 10. So if you have supporting documents or some research articles you want to attach, that's where you would do that. And then again, your name, first and last, or you can just say anonymous, Jane Doe, whatever you would like to put there. And then you select a category here. And there are a lot of different options for the category that you're submitting under. So that's what this looks like.
Let me just jump in to say, you can either put your comment in this field that says comments, or you can upload it as a PDF. And then if you're submitting, if you want to add attachments, essentially anything you want them to read, this is your opportunity to say, I wish the Department of Education would read this. You can also add those files along with your rule. You should label them attachment 1, attachment 2, attachment 3. And your first one, label it as comment.
Yeah. So then there's another site that I didn't already have pulled up. So it's handsoff9.org. And this is another place that you can submit your comments. So this is what the main page looks like. And when you scroll down in under Take Action, you'll see the Submit a Comment button. And then here's where they Know Your 9 has given some guidance for that comment. And then here's where you can actually submit. So you have to enter all of this information first or register with your Facebook to get through it. But we just wanted to show you what this looks like as another option in case you decide to go with this route. So
and this ultimately, that steers it through into regulations.gov as well. And then Kelsey, you can talk about handwriting things, if you don't mind.
Yeah, so like we mentioned, you can also handwrite comments. And if you decide to handwrite them, I believe, let me check really quickly. The information for where to send those should be here as well. So if you decide to handwrite a comment, it's really important that you write legibly and that it's really clear and easy to read. So that way, nothing in your comment gets misconstrued or mislabeled, and that it's still an effective comment. This is another way to kind of slow down the implementation of this rule because again, someone has to read through every single word, and it's you can't, control F to find something in a handwritten comment. And so that's a good way to do that. So here's where you can see who to address the written comments to. So again, it's just in this main page when you open up the regulation on regulations.gov. And there's the address. All right.
Okay, so we've talked about who can do this, where to do it, when to do it. Now we're going to talk about how to do it in a way that's most effective. And all of this is so that, and to be effective ultimately means that the government will have to review your comment and respond to it. And so when the rule actually comes out, there's going to be this large preamble that goes through all of the comments and responds to them specifically. So this will maximize your likelihood of getting there and having a good comment. So, So here I'm talking actually about a comment outline, and this is just how you can think about it. So I encourage you after this call to cut and paste from this or just write it out for yourself to think about, okay, how do I want to actually sit down to write this? So the first thing you want to do is cite the docket number, and I have that for you, Ed 2018. Ed is the department, 2018 is the year, OCR is the name of the agency, the Office for Civil Rights, and 0064 is the number. So you cite that docket number so then they know what rule you're talking about. Paragraph 1, introduce yourself. I am Kerry Simon. I am a Title IX attorney, and I represent survivors across the country under Title IX. I find this rule to be really harmful to the clients I have served. Let me tell you why. Or, hi, I am a parent of a college-age student. I am really concerned for his or her safety and well-being under this rule. Let me tell you why. Hi, I am a survivor of domestic violence. Let me tell you why this rule does not work for domestic violence survivors. I am a community-based advocate. I work with survivors every day. They rely on this rule. Here's why I find it to be. I'm going to explain to you why I'm concerned with the rule. So just introduce yourself and sort of what you have relevance. If you have a lot to say about you can also go on more about yourself specifically if you so choose. So you can think about how you're going to use your expertise and experience to address actual pieces of the rule. But rather than sort of having one long narrative that mixes things up, really for the purposes of being effective and getting them to see what you're trying to say, using headers and bold and numbers to make sure they're really seeing what you're doing. So I would suggest introducing yourself and then say issue of concern number 1. Let's say, and we're going to get into the substance of this later on, but let's say, your first concern is off-campus sexual assaults. So you might say issue 1, sexual assaults that occur online and off campus. And then you discuss, why what they've proposed is harmful to survivors. And ideally you cite next to your issue 1 where in the rule they're talking about. Then you say why this is harmful to survivors. So for example, with off-campus sexual assault, that the vast majority of students, 87%, live off campus. So that's where a lot of sexual violence is happening. So this will prevent those survivors from having their university address the sexual violence they've suffered, and will lead them potentially to either sit in class with the person that harassed them or not go to class at all. Then you support your claim with experience, knowledge, and data and expert opinion. And if you can, again, you can attach any documents you want. So you say, this is my experience. I stopped going to class. Or I would say, this is my client's experience. They dropped out of school at a 50% rate or 30% rate. So you talk about whatever you want to share about your experience and knowledge from your clients, as a therapist from your clients, or from an advocate's opinion from the advocate's world. Then you also cite to data and expert opinions. For example, the work that's been done out of Oregon by this woman Fry on institutional betrayal and what it means to go to your university and have them dismiss your case, and how that makes a victim feel, and other things about, so let's say you're arguing that something will chill reporting. sort of looking at numbers of why victims choose not to report and why what is being proposed might cause them to do that. And then ideally adding in expert opinions, data, and other sources to support your claims. The more you have of that, the stronger, the more substantive you're considered. And one of our last slides here is going to be a list of resources that includes a data guide and other guides that point out each of the issues that we're going to talk about here and where they are in the rule. So those things will really help you sort of plug in things that can help you have a more effective rule. And then finally, to your issue, you say you propose the alternative. You should investigate sexual assault that happens between students off campus because we're all going to be in class together, right? So you would propose an alternative in the end. So you say, this is my issue. This is why it's harmful. Here's why I believe it's harmful. This is my experience. This is data that supports my opinion. Here's what I think you should do instead. Then you repeat and you pick as many issues as you want. You can do 1, you can do 5, you can do as many as you feel comfortable with. Again, length is important, and also they have to respond. So feel free to pick all of the issues that you feel are wrong or that you at least want to try to address. So you do issue 1, and then you do the same outline that I have there. Issue, why it's harmful, what your experience or knowledge or data is to support your position, your proposed alternative. And your alternative can be that they don't regulate on this at all. So you could say, leave this alone. Leave this issue alone altogether. Or leave it how it was, which was better than it is now. Then you repeat that with your issues 2, 3, 4, etc. And then you close and say, thank you for reading my comment, and I please urge you not to implement this rule and to follow my suggestions, and you can provide your contact information if you feel comfortable. So that's really what your rule is going to look like. Or excuse me, your comment to the rule is going to look like.
So here's some comment tips to help make your comment more effective and to necessitate a response from the department. So one is using data to support claims. As Kerry mentioned, we have a data guide that we will show you that Know Your 9 put together. And there are a lot of resources for this. So you can use the data in this guide. You can also, if you have access, I know I as a student have access to the library database of articles, and so I can use that to find articles specifically on trauma and how that impacts school, or anything that related to my concerns, and so I can use that data and then attach that into my comment. Including narratives, again, is super helpful because it will give your comment credibility to say, this is how I know that these are harmful, or this is my experience with this. And it will show that you have that you're credible and that the department should listen to what you're saying. Again, organizing with headers, we want to make this clear, we want to make it easy to read, and we want to make sure that nothing gets lost in this. So you don't necessarily have to follow like APA formatting, for example, but create some headers in there to divide up your comments so that it's easy to follow and it's clear which part you're talking about throughout. Citing specific sentences, phrases, or paragraphs. Again, we've got some resources that will show you that have really, we have lots of lawyers who have done a lot of work to put these resources together. And they talk about, the issue, so off-campus and online harassment not being regulated or not being included in this, and then here's where that is in the rule. And so you'll want to include that again so that it's clear what you're talking about. Upload attachments. If you find a great article on dropout rates of survivors and you want to include that, upload it and put it in your comment that you're uploading that. And then offer original argument. I think this one is really important and something that this is why we're really stressing how to write your own comment. So oftentimes you'll see some form comments, and I was poking through some of the public comments yesterday and noticed a lot of form comments. And so form comments are great. For what that is an organization puts out a comment that says, I'm writing this specific rule, and I think that this is really problematic. I urge you to not move forward with this proposed rule and revert back to the previous law. If 10,000 people all submit that same comment, it shows support for the way that Title IX currently is, but it is not something that the department will have to respond to because it's not substantive and it's not an original argument. And so a more effective way to do this is to offer an original argument. So you can certainly look at other comments that have been submitted. You can look at those form comments and then create your own comment that will necessitate a response on the part of the department. And then again, suggesting alternatives, which you can say, we don't think that you should, or I don't think that you should regulate this at all, and that the schools should be responsible for this, or you can say, I think that it should go back to the way that it was before, or you can come up with your own creative alternative based off of your own knowledge and expertise. So really take this opportunity to put forth what you would want to see and what you would want to work under. And we encourage you to be creative or to simply suggest not regulating.
Okay, we're going to take a break here before we get into the substance of the rule, essentially what this rule did and issues you might want to respond to. We have talked about a lot of things today. We talked about what Title IX is, how OCR has been interpreting it. We talked about why it's important to submit comments, who can submit comments, and when, and where, and how. It's a lot already. So we want to take a minute to take questions, if there are any at this point, sort of about all the things we presented on before we get to the substance. And after the substance, we can stop and ask, take more questions about that. So Maria, can you let us know if folks have had a chance to submit any questions, if there's anything we can respond to at this point?
Yeah, there are a couple of questions that came in. The first one is, if there are 4 different points I want to make, can I submit 4 separate comments, or should I submit all my points as one comment?
I would suggest submitting all your points as one comment. I don't want there to be a narrative that the same people are actually, maybe there's 50,000, but really it's the same 5 people. So I think that you will be better suited to create one comment with clear headers saying issue 1, issue 2, issue 3, and issue 4.
Great. The second question is, you mentioned submitting comments addressing the issues in the order that the issues are outlined in the proposed rule. If we don't do that or mess up trying to do that, do they still need to read and respond, or can they ignore the comment?
They still have to respond. You're just trying to make it as easy on them as possible to really see the issues that you have. So I wouldn't stress about that, especially if you're like, really the main point I want to make is this one. As long as you can cite to where it is in the rule and say, and like quote language if you can, that will help you. And some of the guides we're giving you will help you. Like this rule, we'll tell you where the rule is, but it's 149 pages and it's kind of hard to read. Though I totally recommend reading it if you're able. But these guides really help you zero in on the language that are your issues of concern.
Great. And a third question is, since this proposed change is a change of law, does it have to go through Congress?
It does not have to go through Congress. Great question. So, Congress wrote Title IX, that first rule. This interpretation does not. Instead, because it's getting this public comment, it has this higher status than other guidance that didn't go through public comment. So Congress can act. This is what Congress could do. Congress could say, hey, department, you're totally getting it wrong. That's not what we meant at all. And they can make new legislation revising Title IX to explain themselves. That's unlikely to 0% going to happen, because it's just not going to happen. And it wouldn't be signed by this president, who's the one that is essentially doing this as the administration. But I totally hear you on, what's Congress's role in this? So this is one of those things that the government can do, the government being the administration, do without Congress. They get to interpret Title IX. That's part of their prerogative, and this department gets to do that. They have to get our comment. That's it. But we don't have to have an act of Congress, though Congress could override it in theory. Unlikely, very, very unlikely to actually happen.
Great. And then another question is, if it's partially form letter, but with unique personal experiences or different data articles, do those count as separate comments that warrant a response?
Yes, so that's okay. I think that if you want to start with a form letter to make sure you have the basic information in and then put all your narrative in, that will count as a more substantive comment to the extent that you make it more substantive. So the department can hire a bunch of people to review these comments. And some of it will be doing kind of Control F, looking for sections, and some of it will have to be hand read. So the more you can make yours unique, the better. But I don't think it's a problem to have your opening line be the same to the extent you want to, but I would change it as much as you can, but don't be super stressed about that. I think that the having really strong of your own paragraphs that would make it really effective.
Great. And then it looks like this is the last question that has come in right now. People may still be typing, but this question is it still sub-regulatory?
It's a great question. I think that it's changing its status to being not sub-regulatory, to being regulatory. And I'm going to have to get back to everybody on that exact distinction before I can feel like I can confidently explain it to you. So let me get back to that questioner. If you could send me their name, I will send it back to them.
Will do. And then a couple of people have been asking whether this webinar is going to be recorded and available for others. And the answer is yes. We are currently recording the webinar, and you'll get a link in the follow-up email, and it should be uploaded to our YouTube channel within 48 hours. And we do have another question that just came in. So it says, if we point out something that seems necessary to address, like the rule contradicting itself, does the Department of Education have to change it, or can they still say, thank you, we don't care, it stays as is?
Yeah, it's a great point. So there might be a lot of like, hey, we read your comment, thank you, we don't care, it stays how it is. So I think like that when we're talking about these types of comments, it's possible that it will be changed, but that's only one of the 4 reasons you would do this, right? So the other reasons why you would point out this contradiction is so that later when it's being challenged in court or being challenged by the next administration or being overchanged by the next administration, they can look to things like your comment, pointing out these internal inconsistencies to help them, to help on that side of things. It would also be something that, you know, if you sent your comment to the media, being like, this is the comment I just submitted, and I'm also submitting it to the Denver Post, then
hold on, Kerry, 1 second. It sounds like some folks have lost audio. If you can raise your hand if you can hear us. Great. Okay, just wanted to make sure that we had audio. So sorry to interrupt you, Kerry, but it looks like people do have sound.
Okay. So the question was, can the department just say, your comment to us about contradictions within the rule, thanks for pointing them out, we disagree, we're keeping it as is? Yes, they can. So our goal in submitting comments is not only to change the comment itself, which would be ideal. The goal is also to prepare those who seek to challenge it later, either through the courts or through a new Department of Education. It's also useful for purposes of press and media strategy, and sort of thinking about it from those more holistic perspectives. So it's still worth making those arguments. Or let's say, you know, you wanted to say, look, you're using all this criminal justice language in a process that's not a criminal justice process. You can still point those things out and they can be part of the arguments that you're making. And let's say you decide to, you know, I want to submit this comment to the Denver Post and have them publish it, or to my campus newspaper and publish it. That also could be useful to have written out. So I think it's worth it beyond them actually listening to your role, but maybe they will.
Great, and I think those are the questions we have for now. If you all want to keep them coming, we can answer them in the next break.
Yeah, let me just add one other spoiler alert, which is one of my last slides here, says that I am available to do technical assistance reviewing your organization's comments. I don't know how limited that will be, but I will have some time to do that in January. So, and even over the holiday if you have already written your comment. So if you want to do that, you can email me at C as in cat, Simon as in Simon says, csimon@tfnlgroup.com. T as in Tom, F as in Frank, N as in Nancy, L as in Linda, group.com. I think Maria will send out my email too. So I'm available to review your comments to help you figure out where citation goes and make that as effective as possible. So just want to let you know that now. Okay, so now we're going to get into the second half of our presentation on substance, which is really, okay, so what did this new rule do and why are we concerned about it? And I sort of introduced those 3 big buckets at the beginning. You know, one was allowing colleges and universities, or even requiring universities and colleges to and schools to dismiss and ignore a lot of complaints of sexual harassment. That was one issue. The second issue was tilting the scales away from victims in the favor of those accused of sexual harassment. And then the third was not having as strong of supportive services for survivors. So those are the three buckets we're gonna talk about, and these are some examples. I think we have about 12 or 15 issues that we've highlighted for your considerations as topics to consider, but there's absolutely more, and some of the guides will point you to have even more additional issues. But let's just start with some of these on the narrowing of what schools have to respond to and the standard that they have to respond to them. Man, I'm very fired up about these. So you might hear that from me. Okay, so the first thing that one of the first important things that the rule does is narrow the definition of sexual harassment. So the definition of sexual harassment now under Title IX is conduct of a sexual nature, unwelcome conduct of a sexual nature. So now they're making a three-part definition for what counts as sexual harassment, right? So they're taking a smaller definition of that larger subset that right now has to be responded to, and says they say, unless you fall into this definition, your case is, if you don't fall within this definition, a school must dismiss your complaint. So unless you meet these definitions. So the three are quid pro quo sexual harassment, which is favors in exchange for sexual acts, for example. So give me a blowjob for an A, right, type of thing. That's in the school setting. Then there's sexual assault. That is its own category. And then the third category is the one that's really highly concerning, and that is unwelcome conduct of a sexual nature that is so severe, pervasive, and objectively offensive that it denies one's access to their education. So they're essentially saying you have to endure a certain level of harassment. It has to get so bad that it denies your education. It has to be severe, which is really bad. It has to be pervasive, which means a lot of it and over a long period of time. It can't just be really severe. It has to be severe and pervasive. It can't just be severe. It can't just be pervasive, but it also has to be objectively offensive. A third person, somebody else has to find it to be offensive, not just you. And it has to deny you your educational access. So if you haven't yet had your educational access denied because of this harassment, it doesn't count. So this is a really stringent standard that people have to meet, and otherwise a school must dismiss your sexual harassment report. So I think, for example, stalking, this is disastrous for stalking victims, in my opinion, because early signs of stalking where someone's sending flowers every day, like even if it was every day they were sending flowers, well, is that going to be considered objectively offensive? If somebody can figure out how to stay in their classes, is that going to count under this definition? No. So it is a really severe definition. Same with dating violence. If someone is saying, tell me where you are every day, like just send me pictures from where you are every day. I remember that in a dating violence case, like that kind of control, but it hadn't yet reached a violent stage. So it's basically saying, wait till it gets bad enough till we have to dismiss it. And honestly, who's going to come back after they've had their case dismissed? So this narrowing of the definition of sexual harassment to only the very worst of sexual harassment that's severe, pervasive, and objectively offensive, and denies a victim their access to their education, will mean that a school must dismiss and ignore a lot of sexual harassment. So that's one of the changes. Okay, here's another change that's also limiting the scope and limiting the harassment a school has to respond to. Even if you meet that definition of being severe, pervasive, and objectively offensive, and deny your education, if it happened off campus or online, to the extent that it's not part of a campus, school, or activity, it also has to be dismissed. So we know that a lot of sexual harassment and assault happens off campus. I think it's something like 80%, and this is in that statistical guide that Kelsey will point you to later, of students live off campus. I know I lived off campus. I went to school in California, and there was a whole community of us that lived right next to the campus. And I had one of my clients say to me in a case where we sued a university for refusing to respond to rape at a fraternity house, say, what's the difference of what side of the street? If it was on the side of the street where campus is or across, an invisible line where the fraternity house is, we all show up in kids' classes together the next day. And I think that's really the essence of it for me, is that having to face your perpetrator in class, in the union, in the cafeteria, in the gym, makes it impossible to fully access the benefits of your education. And so here, This is another must dismiss if it's not within a school's program or activity. So think, on campus, or think within an activity like that you are, that a K through 12 is doing a cheerleading competition, and there's an assault during the cheerleading competition, that would count. But if after the cheerleading competition they went back to their coach's house, it wouldn't. So this is really, really also problematic. So this is, again, really narrowing the harassment that actually has to be responded to. And also online harassment, and if you think about stalking or the way a lot of sexual harassment is happening, to the extent that that's not considered within a program or activity of the school, which it's going to be hard to make that argument. Also, schools have to have it. So people are just going to have to face a lot of harassment under this rule, or have their cases dismissed. Then the third way, this is narrowing the harassment that a school has to respond to. It says only reports to certain people count. So it has to be someone with corrective authority that this gets reported to. And I should just say this goes through K through 12 and college, right? So only certain people have to respond. So if we think about that, they're really pushing you to a Title IX coordinator or someone with corrective authority. So it was that if it was someone who, like a professor, for example, would not count under this, where historically it has. So not your coach. They don't necessarily have corrective authority over a person, but all the time people are reporting to their coach. So it's really limiting the magic person for them to have to take any action to. They do say in the K through 12 setting that teachers are people with that count. So that's at least one positive thing that they've admitted to, but ultimately it's really limiting who you have to report to. And this is the fourth one, and it's not limiting the scope of harassment that gets considered by the school, but it's saying, okay, so if you've met this definition, it's severe, pervasive, and objectively offensive. It's on campus. They reported to the right person. Now, what does a school have to do? This is like, as a parent, this is really horrifying to me. Here's what the department says. You can expect your school to not be clearly unreasonable. You can expect that your school not be deliberately indifferent in response to sexual assault and harassment of school children and college students. So this is not a negligence standard. This is not an unreasonableness standard. Schools have to be clearly unreasonable in their response before they have violated Title IX. They have to be deliberately indifferent, deliberate, on purpose, indifferent, do nothing. That's the standard that we have now created in our schools. That is not the standard for employees. So we have none of this is not the standard for employees. This deliberate indifference standard is just for our students. This is the level of harassment that they have to. This is the response that we expect from our schools in response. So that is one that I just, it's hard for me to think about as a parent and just as a person that if there was a coach that was sexually harassing a bunch of students at my son's school, and the school responded unreasonably, but not with deliberate indifference, they wouldn't be held accountable. So this is a whole area of what's going on in our schools that allows schools to ignore harassment and doesn't hold them accountable when they do respond, unless they respond with deliberate indifference.
All right, so the next bucket that we're going to dive into here is the way that these proposed rules tip the scales in favor of the named harassers. They create an unfair process and chill reporting. So the first change is this would push schools to adopt the clear and convincing evidence standard. So for those that are unfamiliar with evidence standards, a common standard to be used in civil proceedings, also in student conduct proceedings, is the preponderance of the evidence standard. So the preponderance of the evidence standard says more likely than not, this is what I think happened. So really it's 51%, this is more likely what happened. And this has been found to be the most equitable standard of evidence because it assumes that both parties are kind of starting from an equal place. And then throughout the proceedings, throughout the investigation, whoever is finding responsibility or not will be swayed one way or the other, but both parties or all parties, if there are more than two, start from an equal playing field. The rules as they're proposed say that schools will be able to choose their evidence standard unless the school uses a clear and convincing evidence standard anywhere else. So somewhere that this happens is for union employees. And so if a school uses clear and convincing for their union employees, they must adopt clear and convincing for Title IX hearings. So this is really problematic because, like I mentioned, when I was doing conduct hearings, previously working at a university, we used preponderance of the evidence standard for everything else. So even like for physical assaults, if we were having a student conduct hearing, we would use preponderance of the evidence. And so when the department is saying that you must adopt a higher standard of evidence for these cases, that's really inequitable and problematic because it creates more of a burden than for, for example, physical violence on the survivor to prove that their story is true. The next one is the live hearing with cross-examination. So this would apply to college and university students. So they would be required to have a live hearing with cross-examination. And I think that most of us on this call can imagine how problematic this is and how re-traumatizing it can be for survivors. And not only just to have that cross-examination of having your questions, or excuse me, your story questioned by someone else, but the accused or the named harasser can choose their own advisor. And so they can have a super successful attorney, if they have the means for it, come in and question the survivor's story. And that just really, again, like tips the scales in favor of that named harasser, because if they have the resources to pick someone who is really savvy in this area, not only are we then questioning a survivor's story and creating a higher evidence standard that they must meet, we're also creating an inequitable process where students who have the means to hiring attorneys are given more of an opportunity in this process than others. And then you'll also see here, if the named harasser does not have an advisor, the school must provide one to conduct the cross-examination. So this just gets really messy with, it seems to favor the education and the right of the named harasser to be at school over the person who has over the survivor. So I think that, like I said, I think that we all in this call have experience in some way or have some concerns with survivors having to repeat their story and make sure that they're meeting all of the things that Kerry already talked about, and that it's severe and pervasive, and they tell the right person, and that it happened in the right place. And so now if we're also expecting them to experience cross-examination and be questioned on their story, we can imagine that this will lower the reporting rates, because I know that if I would not report if I knew that I was going to be cross-examined. The next one is the appeal rights. So students that are found responsible for sexual harassment can appeal their sanction. However, the victim would not be able to appeal the sanction to, like as written here, for example, that a suspension should last until graduation. So this, again, tips the scales in favor of the named accuser, because they would have appeal rights that the survivor would not be able to, or would not be given. Yeah, and Kerry will talk more about some of the supportive measures that could be applied under these rules. But these appeal rights are really problematic because, again, we're coming at it from an inequitable standpoint. So it's not even that both students are given the same appeal rights and fair due process. It's that the person who is found responsible for sexual harassment or assault would be given more of an opportunity to appeal than the victim or survivor. Fourth, there is no time frame given in these proposed rules. and there would be the opportunity for an indefinite delay for criminal proceedings. So right now, if there is a criminal process happening at the same time as a Title IX investigation, they can run concurrently. And what this rule would do is it would say that the criminal proceeding would take precedence over the Title IX investigation or the civil proceeding, or excuse me, the Title IX investigation. And so this, if the criminal proceeding is taking a year or more to happen and to conclude before the Title IX proceeding could start, we're talking about a significant impact to a survivor's education. If they're continuing to have to be in class with their the named harasser, or if they're living in the same hallway in their dorm, and they're having to wait for this criminal proceeding to be done, it's likely that they will leave school, be pushed out of school, or simply choose to no longer be there, so they don't have to deal with this person anymore. And finally, the proposed rules come from the presumption that the survivor is not to be believed. I think that there are a lot of ways that this rule communicates this, and one is just in the way that this rule is being talked about. So a lot of the rhetoric around it is that this rule is needed to increase due process, and make sure that we're not getting all of these false accusations, and that we're protecting people from false accusations. Well, the percentage of reports that are false is actually really, really low, and you would not know that based off of the way that it's being talked about right now. But false reporting is super uncommon, and it furthers the misconception that women are crying wolf, or being too sensitive, and that they are being favored over these men, when that's not the case. When we're working from preponderance of the evidence standard, when we're working from equal appeal rights, we're saying that both students have the right to access to education, and that these claims must be taken seriously. And I think that these proposed rules really do further the stereotype of women falsely accusing men, and therefore having to prove that this actually happened to them through higher standards, and a cross-examination and a live hearing. And I don't think that that's the way that these cases should be handled in schools.
Before we go on, I just wanted to add a couple of points onto top of what Kelsey said, and thanks so much, Kelsey, for all of that, on a couple of these points. So the first on clear and convincing, just to make this really clear, because you have to use the same, if you use clear and convincing anywhere else in your school, you have to use it on sexual harassment cases. A lot of union employees across the country have through union negotiations gotten clear and convincing for their conduct. So just another form of misconduct that's unrelated to sexual harassment. So that would be brought in. So even a school like if GU or any of our schools really wanted to say, okay, you've given us the option of clear and convincing, we in Colorado want to stick to preponderance. They can't if they have one union employee who would get this clear and convincing standard. So it's going to input that into a lot of our schools. Even if we think, okay, well, my school won't do that to me, they might have to under this rule. Want to point out on this live hearing with the cross-examinations, that if a victim says, I don't want to be cross-examined, I refuse, then they cannot have their statements considered. So their statements get taken out. They can't be considered before the hearing panel. So this means, lots of times we know in the criminal justice system, for example, victims don't participate, but the state needs to move forward with it anyway. And there's cases when a school might want to move forward with the case without a victim's participation, or the victim might want to participate with everything except having to be cross-examined. But her statement is going to be taken out and not be considered. And so she's really going to have a hard time succeeding on her case when her statement can't even be considered. So it's really extreme, that part of the cross language that's in the rule. On unequal rights to appeal, what I point out is that in an earlier, when Betsy DeVos rescinded the 2011 Dear Colleague letter a year ago, she had this unequal rights to appeal. And it was a little more extreme then, but it's still really bad. She had a footnote that's super concerning to me, and I think about it all the time. And the footnote said, the accused student has their education at stake, and that's why they're getting this unequal right to appeal. That's why we could give them only the right to appeal and not to the other party. Well, I'm like, have you ever talked to a victim? Their educations are on the line too. I mean, that's the bottom line. What we have in our statistical guideline is that 34% of victims drop out of school. And we know that from all of our practices. We work with victims all the time, and their education is 100% on the line in these proceedings. And so to say that only the harasser found responsible should get the appeal right when it's as if it's not fully going to limit the victim's education is really concerning to me. And I think they've really shown their card that they think it's an outright denial of education to those accused of sexual harassment, but a limited effect on the education of victims when we know that's not the case. Victims also have their education on the line. Finally, on this presumption of survivors is not to be believed, there's actually language in the rule that says that there is a presumption that the respondent, the person named for harassment, is not responsible for the sexual harassment. Essentially, it's like an innocent until proven guilty. It's not responsible until found responsible. So there has to be presumption that when they get their original letter and the victim gets it too, saying there's been a report against you, there has to say, we presume that you are not responsible. So that's where we say this presumption that survivors not to be believed. It's actually part of the rule and written into the letter that everybody gets. So just wanted to make a couple adding in to how concerning some of these things are. Okay, so the third big bucket that we wanted to talk about was changes to the rule on this idea of remedies and accommodations that survivors get in response to sexual harassment. So one thing that's positive in the rule and was already in place before this rule was that regardless of whether you move through a disciplinary process, you still have the right to accommodations and remedies. But they have this new word in there, so it's called supportive measures. They don't use accommodations and remedies, which really irritates me because those are classic language that really have full meanings. Remedies is remedial measures that look back on how to address the sexual harassment, address the impact of sexual harassment, and accommodations is a word, but they have this new term that they want to use, supportive measures. They're applying it equally to survivors and to those accused of sexual harassment. And so here's some of the ways that they're harmful. The first is, if you're going to have a no contact order, it must be mutual. So I think those of us who work in the community and do protection orders with survivors, we all know that you don't have a protection order that goes both ways. It's only the person who harmed the victim that has to stay away from them. Now in schools, you couldn't have that. A school say, hey, harasser, stop, hey, stalker, don't contact our client, this victim anymore. Instead, you have to say both of you can't contact each other. And one reason that's problematic is that puts a lot of victims in fear that they're going to somehow break this rule and be subject to discipline, and they can be, and they have been. That's actually real risk. Another is harassers often use those no contact orders to try to hook in their victim to say, oh, she violated the no contact order in this way when she did X, Y, and Z. And it's a way that we see, harassers and domestic violence abusers use systems like that all the time. So that's really problematic that schools cannot have it be in one direction. The next issue that concerns me is in the list of possible supportive measures, they have some things that we do want to see for victims, like extensions of deadlines and counseling. But all of the examples they give are forward-looking, things that they have to do in the future once someone is reported. Okay, we should be giving someone extensions on deadlines. But none of them are remedial in nature. None of these list of examples that are in this rule are remedial. Things like, okay, how do we address the impact that's already happened? Letting somebody retake a test or a class, giving them tuition credit when they paid for a whole semester and dropped out, removing impacted grades and W's from their transcripts. Those are things that would make this rule much better. So that's something you could say in a comment, is you should have remedial examples like retaking classes or removing impacted grades, rather than only things that are forward-looking. Because as we know, victims don't necessarily report the day that they're harassed. They have already takes time to report, and then they've already had the impact on them. Maybe they've already failed all their classes. So they need things that are remedial in nature too. The third piece is that the rules language says that these supportive measures have to be non-disciplinary, non-punitive, and without unreasonably burdening the harasser. So that means really a school can't just move the harasser out of a classroom or dorm anymore. I mean, that's what that rule says. So to the extent you find that problematic, that's another thing you can comment on. Another thing I dislike about the definition of supportive measures is that the supportive measures are designed to restore and preserve education, rather than So a school must provide supportive measures. And what are supportive measures? They are designed to restore and preserve education. So historically, language has said a school must remedy harassment or accommodate a sexual harassment victim. So here they could have said a supportive measure restores and preserves education. But instead they added this like window dressing language that says they have to be designed to restore and preserve rather than just restore and preserve. So they've given really schools a big wiggle room to offer something that doesn't actually restore or preserve one's education, but is in theory designed to, and get away with that. So that language should be removed. So on this whole supportive measure front, these are the alternatives that, for example, you could suggest that schools be allowed to or promote the one-way no contact orders like we do in the civil system, that they add examples that are restorative in nature, like addressing impacted grades, remove this non-punitive language, and remove the design to language.
All right, so here are some of the resources that we've been mentioning throughout this webinar. So they're listed all here, and when you get the recorded version in the email, Maria is going to include them for you. But I wanted to just show you what they look like now. All right, so the National Women's Law Center put together a thorough explanation of what these proposed changes are. And so this is where you'll see they have this duty to respond. Here's the notice. So in many instances, schools do not be responsible for addressing sexual harassment, even when employees knew about the harassment. And then here is where they cite where in the rule this is. So this is something where you can look here to write your comment and say, I think that, you know, if a coach finds out or is told about sexual harassment, that they should have a responsibility to further this process to help support the survivor. And then you can point to this this citation here. And there's also these really nice explanations for each one of these. So this is super thorough again, and has the citations in here for you. And then down at the end, there are some really helpful statistics. So these are some things that you can use to bolster your argument. You can pull from these data points to say men and boys are far more likely to be victims of sexual assault than to be falsely accused of it. So this is one great resource. The next one is a 2-pager from Know Your 9. So this is similar. So it kind of outlines what the proposed rules are, and then it explains them. And what I really like about this one is that it gives an alternative, and it says what the Department of Education should do instead. So this is another great one for getting some more in-depth information about what these proposed rules would do and a different way to think about each instance. And we mentioned the data guide from Know Your 9. So this is what it looks like. And again, it'll give you some of these statistics on prevalence that you can use. It'll talk about the economic effects of sexual violence, reporting rates, and then there's also these footnotes here that I will probably use, and I will probably look up these articles to pull more information from them, and I might even attach them to my comment at the end. So this is another really helpful guide that you can pull some data from, or find some articles to pull other data from. And then the National Women's Law Center also put together a sample comment. So this is where you could use this formatting to make it look really official. Make sure that you have the docket number included in the title of it. And then here is where they've already written, I'm writing on behalf of myself in response to the Department of Education's notice of proposed rulemaking. And then you'll notice all of these highlighted areas are where you will want to include your own comments. So this is where you can make the changes to include whatever you feel is most important. And then there's just more information in here for you. And then there's also a link to submit the comment when you're done writing through this sample comment. All right, yes, and then I already showed you regulations.gov, the proposed rule. So we're all familiar with that, hopefully.
Okay, we're going to jump through these last slides. We still have a little time for questions. So I just don't want you to feel intimidated like we've given you too much information. This isn't like it's going to be a million pages. Feel free to submit just a couple paragraphs. If you feel like you can't do a detailed comment, it's the last day, go ahead onto the Hands Off 9 or National Women's Law Center and use one of their forms and get something in. I would just ask you in the meantime to consider setting aside 15 minutes to just do this, and put out an outline. I'm happy to review for you. Make a plan on how you're going to comment. Are you going to do this over your holiday? Are you going to do this over the weekend? Are you going to find time during the workday and invite 5 friends to do it? You're going to do this when you get the email from Maria with all the resources we pointed out, and try to recruit others, just like we do when we're thinking about voting. Is make a plan on how you're going to do it and invite 5 friends. Again, I'm available for technical assistance to review comments. So you can, here's my phone number and email address. You can contact me and I will help you make your comment more effective. So please do. And we'll stop here to take questions on the substantive side of things or any questions folks have at this point. Thank you so much for sitting with us through this presentation.
So we have plenty of questions for you all that have been coming through as you all have been talking about the substantive piece. The first one is, if a party is at a Greek house off campus and someone is assaulted, is that a school activity and could schools investigate?
Great question. So in the language of the rule, they say it has to be within a program or activity. In the preamble, so essentially the way the rule, the draft rule is written, there's this thing called the preamble, which is just a bunch of language where they're sort of talking about it, and then the actual edits to the rule. So the rule itself says no, it has to be within a program or activity. The preamble cites a lawsuit, actually my lawsuit, that found that they do have to respond to rape at fraternity houses because of the amount of control they have over them. So the rule suggests that it would be that fraternity houses would count. I would say that they should say that in the actual rule language itself. So I would say, look, you've suggested that in the preamble, put right into the rule, fraternity houses have to be a lot of rapes happening there, and we need you to include it. So I would ask them, when you're talking about the off-campus piece, saying a lot of rapes happening in fraternities, you've mentioned that in the preamble, but why isn't that in the language of the rule? Please clarify within the rule that fraternity houses, that schools have to investigate fraternity houses rapes.
Great. The next question is, will these changes push reporting directly to local police and the district state courts? If so, is there any benefit? And they commented, I believe the school environment will suffer.
So I think the question is there like a mandatory reporting from the school to the police? Am I hearing that? Is that what it said?
If it will push, so I'm assuming, Jim, you asked the question if you wanted to clarify a little bit more, if it will just mean that instead of reporting to the campus, if it will just push students or folks on campus to report directly to the local police and the district state courts.
I don't know the answer to that from like an imperative perspective. I think that lots of victims already do both. Lots of victims don't report to either. And I don't know, so I don't have an exact answer. Like I think that I think that we should be increasing our options for victims rather than trying to push them into any way is what I would ultimately say. It's great if folks want to decide to report to the police or to their campus or not at all. We just want to present as many options as possible.
Great. And the next question, for the cross-examination provision, what do you think they mean by aligned with?
So I think they're trying to say more than someone that is neutral. So a lot of the way it happens now when a campus has a live disciplinary hearing is that each party would provide like a written list given to the chair of the committee, and then the chair of committee would read those, decide which ones were relevant, which weren't relevant, and then might rephrase them if they were asked in a really shameful or wrong way. So let's say they asked about the sexual history of the victim. Well, the chair of the committee would say, look, we don't allow for that. So he's not going to ask that question. There is some sexual history pieces of this that's not allowed via this rule, but I just bring it up as an example of something that a neutral person would not be aligned with either side. The school is usually the role of the neutral person. So I think what they're referencing is it can't be somebody who's neutrally doing a fact finding. It's not someone who's just interested in the outcome. They are somebody who wants the outcome to be in favor of the accused person. That's what aligned means.
Great. And then somebody was hoping that you would be able to explain deliberate indifference a little bit more, if you could go over it again.
Okay, so deliberate indifference is defined as being clearly unreasonable. and versus what you might hear, which is unreasonable, right? So that's like a normal standard. A negligent standard is we have a reasonable person. What should someone act reasonably? So when someone's unreasonable, you could hold them accountable in a lot of circumstances. Here we're saying, even if a school was unreasonable in response to a report of sexual harassment, that's not enough. They have to be clearly unreasonable, which is this word deliberately indifferent. And the way I understand deliberate indifference a lot of times is on purpose do nothing. So it's like really doing nothing. So our standard that the Department of Education is setting out for what we expect our schools to do in response is if they do nothing, then we're going to hold them accountable. But other than that, as long as they're not clearly unreasonable, it's giving them a lot of leeway, is really what it's doing, and decreasing the standard. And it's not what I want for my schools.
Great. And then another question is, can the named harasser do the cross-examination themselves in the new regulations?
Under the proposed, they cannot do it themselves.
And then would a victim get an advisor or attorney provided by the school as well as the accused?
I can't remember off the top of my head, but I think that the answer is yes, that it goes for either. And so the cross would go both ways. So the advisor of the victim would be able to ask questions of the respondent. And I believe, and I just can't recall, so I'll have to get back to this person to look at the language from the rule to see whether it's the part where they say that you have to find someone aligned with them goes for both.
Great. And then could you please cite the page you are referring to for the inequitable appeals argument? The rule seems to say that both parties are entitled the same appeal rights. It also says that the complainant can appeal if the sanction does not restore their access to a school's program or activity. And it also says that they are not entitled to a particular sanction, which was also the case under the Obama administration.
I'll have to look at it. So when the interim guidance in 2017, in September 2017 came out, it said that there could be unequal rights to appeal. A school could just give rights of appeal to those accused of sexual harassment. Kelsey, can you bring up the National Women's Law Center guide really quick?
Yes.
Appeal section. And now my understanding is that the language in the appeal, at least part of the appeals language, and it sounds like it's just what that person is looking at, does say that a school has the option of giving the respondent the right to appeal the sanction. So that they could both equally appeal the outcome. So if he was found, if the perpetrator was found not responsible, the harassment victim could appeal on those grounds, but not on the sanction. So let's just see if this has a citation to the exact piece that you're looking for. Presumption of harassment, standard of proof.
Appeals, there we go. I passed
Appeals. So schools may choose whether or not to offer an appeal. Okay, so that's a choice. If a school offers an appeal, it must give both the right to appeal. However, if a school finds that a student was in fact sexually harassed or assaulted, the student may only appeal for better remedies, but not a sanction. So remedies are things like I want to get a remedy is something that has to do with how the sexual harassment has impacted them, not a right to a particular sanction. So, this is understood as being language that's giving a difference of a right to appeal on the grounds of appeal. So where either party can choose about whether the sexual harassment occurred, where they found it occurred, the victim can only appeal about remedies. They can't appeal to it for requesting a different sanction.
Another question is, as a service provider, we see mutual no contact orders being implemented in almost all of our cases. As a broader advocacy strategy, do you still recommend for people to include that topic in their comment, even if that is already the norm in many parts of the country?
Yeah, that's a really good question. I think right now, there's a difference between it being the norm and being required. So one, it's not at all schools. I have had plenty of schools that I've worked in that were willing to do single-sided no contact orders, others that refused. But I will say, so even if you think it's the norm, I personally, in my experience, having worked at many different schools, have seen schools offer them in one direction. I think if you think it's a good idea to have them in one direction, and that's something you hope to one day advocate for on behalf of a victim, then you should say that this is wrong. If you don't find it to be the most compelling of the issues, don't pick it. But I am just wanting to raise it for you as something that's now being required where before it was not required.
And we just have a couple more questions. Is there any insight about the evidence being released in electronic format to both parties? And that's in reference to section 106.45 B3 8.
Yeah, I remember that part. What's the question about it again?
Is there any insight about the evidence being released in electronic format to both parties?
Yeah, I don't have a personally, I'd have to think about that a little bit more. I think one thing that's concerning about it is it says that's, I think in that same section, is that the language says that any information that the university gets has to be provided rather than just the stuff that they're using. So let's say a victim just hands over their entire cell phone thinking, okay, well, you figure out what's important. Now that entire cell phone of information gets handed over to the other side. So I think it sort of limits the ability of, I think that's a scary thing for a lot of folks. So I think that part is pretty concerning. How it's provided, I guess, is a matter of whether folks feel like it could later get out in some way, or they're concerned, or would that intimidate somebody from participating if they knew that the respondent was going to get their medical records and have them an electronic copy. Those are some of the things I'm thinking. I think that this is probably something schools are more concerned with than our victims per se.
Yeah, and just as a clarification to that, the person mentioned that their concern is that the information can be copied or duplicated and then shared. People can take pictures or video on the phone, and it may include FERPA and HIPAA information.
Right. So I think that's a similar. So I guess what the question is, what is your concern about that? Do we feel like victims will be concerned that their information, that type of information, will then become publicly available and so won't participate or be upset when it happens? So I think you could raise those things if it was of concern, if you thought it would become of concern to me.
Great, and that sounds like what they were hoping for. The next question is, I've heard from other organizations that we should not suggest in the comment how the department can fix what is wrong because it makes it easier for them to pass the comments with small changes rather than just start from scratch. You know that the Know Your 9 2-pager has those types of suggestions, but do you recommend leaving those out of the comments themselves?
Okay, so I think that's like a strategic question on what purpose that you're doing this for. And, you know, I named two sort of bottom line purposes at the beginning of this. One was having a better rule, and the other was creating a record for it to be challenged. I don't know that it will be successfully changed. And personally, this is my personal strategic decision on that question. I want to see a better rule for survivors. We might be really, really stuck with this. And if I can get something even changed a little, I want it. So I don't, that's not the position I'm personally taking, though I totally understand another position, which is like, look, all of this is coming from a bad place. It's overall extremely bad when all taken together, one little tweak, then they're going to use an excuse to say they listened, and when they really didn't, that's just window dressing. I mean, I think we'll just have to make those arguments when the time comes. So I think that's a strategic decision. Ultimately, if you offer alternatives, they do have to be responded to. So if that's a goal that you have, that's another reason to do it.
Great. And the final question is there anything in the rule that you view as potentially positive for survivors?
Yeah, I mentioned one, which was that they specifically said in the K through 12 setting that teachers are folks that would count as to take. Okay, so I think the teachers one is an example, but I want to back up. What is I would rather be removed altogether, because what's already in place is what is good. So it's not like they've added anything specific new that wasn't already in the rules that was good. So that we, that teachers already would have counted under the last fraternities already were under the last administration and under the rules before this. If it happened at a fraternity, you did have to investigate. So I am not taking things that are like, quote, good, because for the most part, everything in this rule, if they took away the rule, the things that are, quote, good would already be there. So that's really my opinion. But something like pointing out teachers as a specific example is a better part of this rule, is something that I don't have a problem with. But would I take out the rule altogether because teachers already count? Yes. Does that make sense?
Yep. And that are all, excuse me, those are all the questions that have come through at this moment. And we are about 5 minutes over our time. So if you have any other questions that we didn't get the opportunity to answer during our webinar, please do feel free to reach out to Kerry, to Kelsey. If you wanted me to pass on any questions, please do let me know. Thank you all for being here again on this learning about this very important topic. And thank you again, Kerry and Kelsey, for spending your time with us and sharing all of this valuable information. Look out for the email. As mentioned, I'll be sending it here within the next 10 minutes. It'll have this link to the survey. It will have a copy of the PowerPoint, which includes all of the links. And those are clickable when you open the PDF. We do want to invite you as well to our upcoming webinar in January. So it's called Zooming In, Poetry as an Entry Point into Violence Prevention Work. And that is going to be by an MC and two-time national spoken word competition winner. That'll be on January 30th from 12 to 1:30 p.m. Keep an eye out for that. Thank you all again for being here with us, and especially to our presenters.